Hello, my name is Adam Conrad and I am in EDL 850 School Law. Today I will be talking about FERPA, which is the Family Education Rights and Privacy Act. FERPA describes the rules for what records the public has access to. Our schools keep active files on all of our students for a variety of reasons. Placements, IEPs, for future college admissions, health reasons, etc. This is called the Public Law 93-380. This can be also called the Buckley Amendment, which was established in 1974. And again, this is a law that was passed for the confidentiality of student records. And under the Buckley Amendment, there are sanctions for violating family privacy, which states that no funds will be given to any facility if they are not releasing records to the parents. USD 331 is a publicly funded school, which means that we must release our records to the parents of our students. Our policies indicate that if a parent wants to look at their child's records, then the district must let them. If a parent by chance thinks that information is incorrect, they can ask for the records to be amended. This would be if they feel that the records are misleading or in violation of their child's rights. As far as publishing to our local newspapers or any newspaper for that matter, if our district releases student directory information to the newspaper, then the following list is the only information that a school can release. And all this information is very basic information that doesn't divulge any of the student's main privacy rights. As far as the parents' rights to the directory information, obviously, if a parent will sign a consent form, we can release more information. And on the flip side, if they don't want any information to be released, then we can also do that. They just have to make it very clear at the beginning of the year that they do not want a lot of information released over their child. Parent rights. If a parent wants to view their child's records, then they legally can. If by chance my district, USD 331, releases this information, then the school administrator must be present to interpret any of the records. A lot of parents will have questions over what a particular area of the record actually means. So it's very important that we have an administrator there that can make clear of the records themselves. And also, if the records are challenged, meaning that the parent doesn't agree with what we have in the records, then the school should hold a meeting that can be within 10 days of when they make the request. Now, legally, your school has 45 days to comply to that next hearing. One of the reasons why that it is said that we should do this meeting within 10 days is for the obvious reasons that we want to make right any of the concerns that a parent actually has, if they are justified. Also, a school district needs to have the appropriate personnel there while the records are being viewed. We want parents to be very educated on what's in the records, and also so they don't tamper with the records themselves. If no resolution is made, then obviously a parent has a right to bring legal counsel to the hearing. And again, it's going to be the next meeting can be instigated within 10 days of the parent's request. What happens when a student switches schools? When a student leaves USD 331, our school will get written permission for us to release the school records of their child to the next school. The new school officials will be able to access the student records after the parent has signed a written form that says they're allowed to view their child's records. And the next part about the FERPA Act is the rights to non-custodial parents. Parents that aren't supervising their children on a daily basis. And we're in the day now that a lot of kids come from split families, and there's a lot of tension involved with child's education, and so schools can sometimes be put in the middle of that. Even if a parent wants the other parent not to get information about their child, legally we can't do that because we need to divulge all the information to the parents. And this is one of the big cases in New York, where there was a similar situation where one parent says they can't view the school records, and the New York court case ruled that schools should make education records accessible to both parents if of any of the child's fortunate enough to have both parents interested in the child's welfare. And it totally makes sense. Because the records that we keep are about the children, and one of the big reasons why we keep all these records is so that we can make them have the best education possible. So of course both parents should have the right to view those records. And as educators, we have the right to access student records when we have a specific reason to obtain the information. For legal reasons, we need to sign a document stating when and what we are looking at, what information were we specifically looking into. I'm also going to be talking about slander and libel. Slander is an oral defamation of a student, talking bad about a student to people that aren't involved in the school systems or anybody that doesn't need to know the information about a student. Libel and slander both involve communication to a third party, basically anybody that's not involved in the school system. As a policy, USD 331 employees will not talk about student files unless it is with an authorized person. Libel, it's the opposite of the slander part, because slander was the out loud, the oral part, and libel is the written defamation of a person. And educators should avoid writing down information about a student that is unjust or gives an undeserved outlook of a student or a situation that has occurred. One of the big things that we need to avoid is giving your opinion that's in writing it down, and that'll keep school districts away from illegally infringing on a student's rights. The big key with all of this information I've given today is use a lot of common sense with what you are writing down, what you're saying out loud, but also be honest about the information that we need to put into a student record. Keep in mind that student records are there so that we can further somebody's education the best way we know how. We use a lot of student records for IEPs. What is a student able to do? Where are they at as far as their reading level, math level? And the student records are essential for us to accurately put a student in a particular area. And I see a lot of the student records used for behavior plans for students. If there's any medical information that we need about a child, it's very effective to have all that into the student records. And another thing about the student records is that it's not only can go to a parent. Because as soon as a child gets over 18 years of age and they go to college somewhere or secondary school, the student also has the right to view what was in their inside of their files, and they can also call for a hearing to remove anything that's misleading about their their student files. It kind of makes me curious what was in my student file when I was growing up. I have no reason to believe there was anything wrong with my student file, but I'd still be curious to see what kind of information my school district that I grew up in wrote down and compare that to what actually should be going into student files. And thanks for bearing with me through this presentation. It's been real fun, and I'm getting used to Screen-O-Matic a little bit more, but there's still a lot to learn about it. So this was a great chapter. I felt like I got a lot out of it, and I hope the rest of you guys did too.